Right. Just a quick thing about Human Rights Act. What is the origin of it? What is the origin of Human Rights Act? Where it is coming from? Is it something purely originating from Act of Parliament, or is it something which is actually incorporating some other international documents? So we have HRA 1998, which is an Act of Parliament, right? What does it signify? It incorporates the ECHR, European Convention on Human Rights. It incorporates the ECHR. Okay. Now, when I'm saying that the HRA 1998 incorporates the ECHR, what is the significance of this incorporation? What is the significance of this incorporation? How does that impact upon the English legal system? Okay, the HRA 1998 incorporates the ECHR. How does that impact on the English legal system? Right? No. We have done this before.
Those could be true. Taking into account their law and then they interpret
That's section 2. What else? What will be the significance? How does that change anything in the legal system? This is very crucial that we have the HRA 1998, which is an Act of Parliament, which has incorporated the ECHR, which is an international document, European document on human rights. How does that benefit English, the citizens of UK? Let's put it this way.
Sir, UK does not have a written constitution. It depends on common law and both statutes.
What did you mean by more human rights? What actually happens here? Let's put it this way. Let's look back again, different way. UK signed ECHR in 1951. Now the country signing that international treaty, that international document, did it benefit its citizens? Citizens benefit under that document. Citizens will be benefited if they could get protection. From who? From the executive. Citizen protection human rights who violate the human rights? The executive organ of the state actually violates the human rights. Remember, people need 3 sets of protection. 1 set of protection from the external enemies, 1 set of protection from bad elements within the society, another set of protection is needed from the protector itself. That is from the state itself. Again, the protection state. And the state of protection state has the protection through a document like human rights document. Okay, so if the executive, if the state does something bad to me, whom do I go? Do I go to the executive, legislature, or the judiciary? We go to the judiciary. Okay, so the moment we have our rights, the moment our rights are being violated, we go to no one but the judiciary for the protection of our rights. Now, UK signed the CCHR back in 1951. That did not really mean anything because citizens of UK could not have their protection of their rights in domestic courts. They had to go to, from 1966, they had to go to the European court, which was expensive. Okay, so the moment the HR in 1998 incorporated the ECHR, the significance is that what can happen? The citizens in UK can enforce their convention rights in domestic courts. I will do this. So what does it say? It says that the citizens in UK can enforce their convention rights in domestic courts. So that is the significance of having HR in 1998. Okay, you pass it through whom? You pass it through the parliament. That means the parliament incorporates the ECHR, and now citizens in UK can enforce their convention rights in domestic courts. So those who are online, I hope you can hear it clearly that the Human Rights Act 1998 was enacted by the Parliament, which became effective from 2nd of October 2000, and it has incorporated the ECHR, which was signed by UK in 1951. And the significance of incorporating the HR in 1998 is that citizens in UK can enforce their convention rights in domestic courts. Are we clear? So, how can you interpret this? When I'm saying that citizens in UK can enforce their rights in domestic courts, it means that if any of our convention rights are violated, we need to go to European courts. No, we don't need to go to European courts. We can do it. We can seek remedy from the domestic courts for violation of our constitutions. Which rights? What do you mean by convention rights? What do you mean by convention? Does it mean all the rights in ECHR or some of the rights? Where is it mentioned? Which ECHR? We have done this. No, go back. You have the lecture here. Still have the lecture. Go back. See. We have done all these things. অনেক বছর আগে তাই না? আমরা এত ব্যস্ত কিছু মনে রাখা স্যার কত কিছু মনে রাখবে আমি কি এত ঘন্টা করে আপনি কোন পাস জি স্যার থ্যাংক ইউ ফর রিডিং দ্যাট আউট Okay, convention article. Our memory refresh story. Okay, the convention rights are mentioned in section 1 of HR 1998. The convention rights are mentioned in section 1 of HR 1998. For the purpose of HR 1998, for the purpose of HR 1998, The following are the convention rights. So Article 2 to 12 and 14, Article 1 to 3 of Protocol 1 and Article 1 of Protocol 13. These are the convention rights for the purpose of Human Rights Act. Article 2 to 12 and 14, Article 1 to 3 of Protocol 1 and Article 1 of Protocol 13. So what does it signify? Section 1, what does it signify? All the ECHR, the whole of ECHR is convention rights, or it is partial? So section 1 tells us the story that UK Parliament did not incorporate the whole of ECHR. It has incorporated it entirely or partially. Am I clear? Okay. So when I am saying that citizens in UK can enforce their convention rights in domestic courts, does it mean we can go to the domestic court for violation of any rights or just the rights mentioned in one? Just the rights mentioned. We cannot go to the domestic court for all rights. What about section 13 and 20 of every section of domestic court? Can I see clearly? You know, for Article 13, because Article 13 has not been incorporated. It has not been incorporated. Jeshob right, Jeshob right incorporate for a high line section 1A. Jeshob right কি আমি domestic court এ আমি enforce করতে পারবো? Yes or no? I can't. Am I clear? So jeshob right এর violation, jeshob right এর যদি violation আমি কোথায় যাব? Do I go to the domestic court or do I go to Strasbourg? I need to go to the Strasbourg. I need to go to the European. Am I clear? What is how you know what section 1 has done? So section 1 is telling us two things. Number 1, we have incorporated ECHR partially. Number 2, any rights which are not incorporated through the HR 1998, we have to go to the European court, not the. Are you okay? So far? Okay, good. Next one is section 2. Let's look at section 2 of HR 1998. Section 2 determines the relationship. Section 2 determines the relationship. Section 2 determines the relationship between the European Court of Human Rights and the domestic courts. You remember that pyramid structure where we have the Supreme Court, we have the Court of Appeal, we have the High Court, we have the Crown, County, and we have the magistrate court. Right. So this is the structure. In this structure, whom do we, with this, all of them, we have to determine the relationship with the European Court of Human Rights. What is their relationship? Okay. Let's think about a different direction. How about the relationship with ECJ? Is it binding on them? Decision of ECJ, is it binding on them? ECJ is whose court? Highest court of European Union. We have done these basic things long ago. It is the highest court of European Union. And European Court of Human Rights? Is it part of the European Union? I'm not getting any confident answer. Is European Court of Human Rights part of any European human rights structure? The answer is no. Don't make this mistake. It's a very fundamental thing. Do not think. A lot of people start thinking that European Court of Human Rights is probably the highest court of the European Union for human rights. The answer is no. ECTHR has got nothing to do with the European Union. They are two separate organizations. Am I clear? Okay. So, sorry, it's the other way around. The decision of ECHR is binding for them. We know it from precedent. What about ECTHR's decision? Is it binding or is it persuasive? And what would be that? This is determined by section 2. This relationship is determined by section 2 of HRA 1998. Am I clear? Okay. How the domestic courts will react to the decisions of ECTHR? That story, that rule is there in section 2. Okay. Right. Now, what is section 2 telling us? Section 2 is telling us two things. First is, don't write anything, listen first. First is, decision of ECTHR is not binding for them. There is no mandatoriness to follow the ECTHR's decision. You do not have to follow the decision of ECTHR. There is nothing binding there. However, it is binding for domestic courts to take into account of the decisions of the ECTHR. So, it is not binding, it is not persuasive, but it is binding to consider. So, we are having section 2 of HR 1998 actually opened up a different dimension, which was not heard of. We always knew about bindingness and persuasiveness. Section 2 brought a different thing where they are saying you do not have to follow it. It is not neither binding nor persuasive, but it is something which must be taken into account. You don't have to follow. You see, following is not binding, but considering it is binding. After consideration, what you can do? After consideration, you can follow it, you may follow it, you may not follow it. Am I clear? So it's a new dimension that came through section 2. Am I clear? Okay, look at it. The decisions of ECTHR are not binding for UK courts. The decisions of ECTHR are not binding for UK courts. However, courts and tribunals in UK are under the positive obligation to take account of the decisions comma judgments and advisory notes given by the European Court of Human Rights. Court of Human Rights. While interpreting convention rights. While interpreting convention rights. Okay. So what we get here that the decision of ECTHR is not binding on domestic courts. But what the domestic courts are required to do, the domestic courts are required to take account of their decisions when, in all cases, or while interpreting convention rights. While interpreting convention rights. So, if we have a situation, for example, we have a case decided by UKSC in 2012. Okay. We have case 2 decided by ECTHR in 2013, and we now have case 3 for Court of Appeal in front of Court of Appeal. This is 2015. These two cases are conflicting. These two decisions are conflicting with each other. How would Court of Appeal apply Section 2? Yes. That will be the, you get the answer? They will take into account the case 2. If they take into account case 2, that satisfies our requirement under Section 2. And if they follow case 1, that satisfies our rules under binding precedent. Are we clear? But will the court always do that? Will the court always follow the what would be the, you see, that is a common sense answer for Section, if you want to apply Section 2. But generally what the court will do? Will the court always take into account it and they not follow it? Or they are more likely to follow the ECTHR? ECTHR decision, even though this decision is not binding, if you are the judge in Court of Appeal and you have a choice to follow this or that, which one would you prefer? Which one is likely to? Which one will be the last resort here? Last stop. Here. Say if it was other way around, if this was 12 and this was 13, which one would you follow? Whichever way. Which one would you follow? Would you follow the Supreme Court decision because it is one of our judges, or would you? I will not follow the European judges. I will follow one of our judges. Would you go for that kind of finding, or do you think that no, let's follow this either? Well, I ask you, as an individual, which one do you think is more realistic, more practical? So you want your own things. Good. Why do you go for speed? Which one would you follow? You
No. I just consider this education school.
So you will ultimately follow Supreme Court, right? How many of you will follow Supreme Court here? Daniel, why would you follow Supreme? Why would you follow ECTHR?
So, I can raise my hand because doesn't have only yes. I would follow what it is. Not very interesting that you say which one I take as the last one. I will go for this.
Well, let's think practically. If case 3 follows Supreme Court, okay, say if we follow this case, there is likely to have an appeal to ECTHR, and ultimate appeal, if the ultimate appeal lies to ECTHR, then what would ECTHR do? Will it follow its own jurisprudence or will it follow its own? So if you think about the practical way of dealing with it here, which one will ultimately stand? So you see, if you look at the approach under section 2, what is the common sense approach of the judiciary? The judiciary thinks on 2 points. Number one, if they always follow their own decision, then there was no point of UK becoming a member state of ECHR. Then what about your treaty obligation? You are saying that I am your club member, but look, I don't want to follow your rules. It's simply like that, isn't it? Right? So if you want to fulfill your treaty obligations, United Kingdom as a state, if it wants to fulfill its treaty obligations, it should follow the decisions of the ECTHR, because that makes more sense. That would make the legal system more compatible with the European Convention. Okay, so that's one thing, one point of dealing with it. Another thing is, think along this line. English courts, the courts in UK, are also public bodies under section 6. Okay, so to have a better understanding of section 2, we need to have a good understanding of section 6. Okay, so let's look at section 6 and we'll come back to section 2 again. All right, write down. Under section 6 of HR 1998, section 6 of HR 1998, it is unlawful for any public body. It is unlawful for any public body to act in a manner, which is in violation of convention rights. Of convention rights. Let's stop here. So what is this saying, section 6? Public bodies, let's interpret. If the public bodies do anything which is in violation of convention rights, what will happen? This would be regarded as unlawful. Who will declare it unlawful? You, I, anybody. So let's see what will happen if any public authority does anything which violates convention rights. What we can do? We, the citizens, can go to the court for a judicial review. Very good. We can go to the court and seek remedy. And if the court is satisfied, what the court will do? The court will declare it unlawful. Whose power is higher? Public bodies' powers are higher, or the court's power is higher? Because the court can review your activities and can declare it to be unlawful. Am I clear? Okay. Now we have to understand who are the public bodies under section 6 and who are not the public bodies under section 6. Okay. So number one, let's look at the public bodies. 3 public bodies. Number one, under section 6 there are 3 categories of public bodies. There are 3 categories of public bodies under section 6. And that includes, number one, courts and tribunals. Number 2, core public bodies. Core public bodies. Ministry of Education, Police, Taxation, NBR, all of them. And number 3, private bodies or organizations with functions of public nature. With functions of public nature. So 3 categories of public bodies, 3 categories. Number 1 category is courts and tribunals. Number 2 is the core bodies, which means government departments. And number 3 are the private organizations, but they have functions of public nature. I'm going into that later. But let's think about, let's link up section 2 and section 4. So section 2 and section 6. Under section 6, you are a public body, right? Which means, can you do anything which is in violation of convention rights? The answer is no. Okay. Then, under section 2, even though you are not bound to follow ECTHR, can you really follow anything else? If you tie up section 6 and section 2 together, where you are saying that as a public body you must follow fundamental rights. Okay, otherwise your activities will be unlawful. On the other hand, section 2 you are saying it is not mandatory for you to follow the CTA. But if you look at 2 and 6 together, do you really have a choice? You are people. Because you are now under obligation to uphold fundamental rights. There is a possibility that if you do not follow this data, that you will be in violation of fundamental rights. Plus, there is a point of following the treaty obligations of ECHR. If the country does not enforce the fundamental rights through its legal system, is the country following its treaty obligations under the ECHR? Not following the treaty obligations. Am I clear? Okay. So for those two reasons, the courts generally what they do, they follow. Am I clear? Okay. The courts, English courts, attitude is very simple. They are saying we will continue to follow European courts' decisions as if they are mandatory, even though they are. Okay, so there's a difference between something becoming mandatory and something becoming something is mandatory, but there is a difference is that something not mandatory but being followed in such a manner and there. So help us again. Second option is not mandatory. It is not mandatory for me to follow him, but I am following him as if he is mandatory. Then who is imposing it? Signature is imposed by the court immediately imposed. Court immediately imposed. So the court immediately goes there, I will follow it, even though it is not mandatory for me. Cannot otherwise, some other way I will be in violation. Some other way I will not be able to implement the European Convention. Right here. Okay, so they will always follow. The chances are they will always follow. The House of Lords clearly says, in absence of any special circumstances, the courts in UK will continue to follow the decisions of the European Court of Human Rights. That is the standing. Okay, that means when they will not follow, if and only if there is a special circumstance. Special circumstances talking about it. So the Parliament আমাকে বলে তুমি European Court to follow করবে না, immediately only then, হবে otherwise will always follow European Court. Are you clear? Okay, let's move on to section 3. Section 3. So we now know what is section 1, we now know what is section 2, we now know what is section 6. Right? If I want to sue my neighbor for violation of my privacy, can I do that? Under Human Rights Act, can I sue my next door neighbor for violation of my privacy? Why not? Why not? Because my neighbor is not a public body. So what do I have to prove? What if I want to seek remedy under Human Rights Act? What are the two things that I have to show? Yes. So that I'm suing a public body, number 1. Number 2. Yes, very good. The rights must be mentioned in section 1. If it is not mentioned, if it is not one of the mentioned in section 1, then I can't seek remedy under Human Rights Act. So section 1 and section 6 are very important there. All right. Okay. Begin. Under section 3. It is important. Sorry, I want to say it is a positive obligation. It is a positive obligation for UK courts to interpret all laws in such a manner so that they can be read and given effect. So that they can be read and given effect. Compatibly C-O-M-P-A-T-I-B-L-Y, compatibly B-L-Y, with conventional rights. So far, it is possible to do so. Yeah, actually, so far it is possible to do. Comparatively to conventional rights, so far it is possible to do so. So, section 3 obligation is on whom? On the courts on courts. What kind of obligation? What do you mean by positive obligation? An obligation imposed by the parliament is always mandatory. But what do you mean by positive obligation? That means there is a negative obligation as well. Am I right? What is commission under the common law? So you don't have criminal law, right? So let's not go into that. Now, think about it. When I'm saying positive obligation, it means you are asked, you are under obligation to do something. When I'm saying refrain from doing something, then you are, for you it is positive obligation or negative obligation? It is negative obligation. So if the act says, if any law says that do not interfere with the privacy of the population, of the citizens, what kind of obligation it is? Positive or negative? Negative obligation, because you are asked not to do something. And when you are asked to do something, it's called positive obligation. So what is the obligation of the courts here? Under section 3? কি করতে হবে কোর্টকে? পড়েন। Read section 3. What they will have to do? They will have to interpret. Interpret what? This is a mighty word. All laws. What does this include? This all includes. All include everything, isn't it? And what is that everything? UK law and EU laws would be included in it? No. take a note. All laws include primary law and domestic law. Sorry, primary law and secondary law. Primary law and secondary law. What is secondary law? Delegated legislation. And what is primary law? Act of Parliament. So to interpret all laws, so all laws being the primary legislation and delegated legislation. Okay? All also includes laws irrespective of their time of enactment. Which means not only the existing laws but also future laws. Laws that's going to be made by the Parliament in future. Am I clear? So you can write all laws also include existing and future laws. Existing and future laws. Let's look at section 3 again. Obligation on whom? Obligation on the courts. What type of obligation? Positive obligation. To do what? To interpret all laws. Which way? In which manner? You interpret them according to the convention rights. Is it just according to the convention rights? Or something else we need to add? What is that something else? Look at the last part. What does that mean? So far it's possible to do so. Yes, I know the Bengali meaning. What do we mean by that limit? Where can we derive that limit? Look, you have done a statutory interpretation, right? Remember statutory interpretation? You have done it. The courts, when interpreting any statute, what they have to do? They have to uphold the intention of the Parliament, right? If we just go by this, then there is no point of having intention of Parliament. Okay. So far, it's possible to do so means that laws must be interpreted according to the convention rights. So far, it is allowed by the intention of the Parliament. Okay, which means under section 3, if you want to interpret any law of United Kingdom, okay, under section 3, it must fulfill how many conditions? 2 conditions. Number 1, they must be interpreted according to convention rights, but that interpretation must be done within the intention of the Parliament. দুইটার যে কোনো একটা যদি ভায়োলেশন হয়, section 3 is not applicable. Am I clear? Yes. লিখেন under section 3, two conditions must be fulfilled. Number 1, all laws must be interpreted compatibly with convention rights Number 2, the interpretation of rights. The interpretation of rights must be within the intention of the parliament. So if these two conditions are fulfilled, only then section 3 can be applicable. What if we can tick on this one but we can't tick on this one? Can we apply section 3? That's it, we can't apply section 3. It will have to be that we tick this one and we tick this one. If we can tick both of them, only then section 3 is applicable. And if section 3 is not applicable, we have to move on to section 4, which makes the law incompatible. It's a declaration of incompatibility under section 4. Am I clear? Now, section 3 is very important for statutory interpretation. Look at this. What I'm saying, all laws must be interpreted. Now, think about the traditional approach. Traditionally, statute interpret kora hoy kokhon? When there is no. Traditionally, statute is kora hoy kokhon? Interpret kora hoy kokhon? Literally, when there is ambiguity, when there is absurdity, when words are not clear, isn't it? Am I right? Section 3 is more ambiguity. Section 3 is more ambiguous. Section 3 apply. It becomes anything like that. Section 3 is telling us you interpret, you apply it, you interpret all laws according to section 3. Doesn't matter whether it is ambiguous or not, whether it is clear or unclear, you have to apply section 4. Otherwise, it's not. Otherwise, you can't apply it. Are we clear? So far? Okay, good. So in our next class, we'll look at the articles. We'll look at Article 6 basically. Okay, but we have to look at Article 8 to 4 as well. I'll post for the book. একটু অ্যাটেন্ডেন্সটা দিয়ে যান, ওয়েট করেন। Articles are from the difference actually. Articles are